Okay, good afternoon and welcome to Avoiding Sand Traps in Tribal Real Estate Deals. Our presenter is Shauna Coons, who also is a former board member, just to follow up on Matt's discussion. So if you have questions, ask her. We've got a few more running around here too. Shauna is an enrolled member of the Lac Courte Orielles, thank you, sorry, Slaughter. Band of Lake Superior, Chippewa, and is managing attorney at the Kui Law Firm, where she assists tribal governments with real estate business and governance matters and a variety of tribal and federal Indian law issues. Most recently, she secured a historic reservation proclamation that added over 2,000 acres to the Lac Courte Orielles Reservation, and actually she presented on that last year, which was really fascinating. And our co-presenter did not make it, so without further ado, I will present Shauna. Anybody who wants to get continuing education legal credits, there is a sign-up sheet over in the corner over here.
Thank you. Buju Ginawa, Shauna Nindigena Kaz, Jaganashimong, Adash Gajekwe, Nindigo, Ojobemong, Makwan Indodame, Adawa Zaga Igining, Ijinakate, Ishkonigan, Winjabayan. Good afternoon, everyone. My name, again, is Shauna Coons. I'm an attorney at the Kui Law Firm. I'm a private practice attorney, sole practitioner. I just formed the Kui Law Firm about 2 months ago, so it's a new venture for me. Prior to that, I was working here in the cities in a boutique Indian law firm, doing similar real estate business and governance issues with tribes and their business entities. Before that, I was at a mid-sized law firm here in the Twin Cities for several years, again, doing similar work, some gaming, but a lot of business and tribal real estate. I have also worked in-house for the Mille Lacs Band of Ojibwe, was there for 4.5 years, did housing and worked in their community development department, representing the tribe on contracts, construction issues, landlord-tenant issues, mortgage issues, and then also got to do, much like in tribal government in-house positions, a little bit of child protection, a little bit of employment law, a little bit of anything that comes through the door that someone's got a question on. I've tried my best to help out. I've also clerked in Hennepin County and worked for Judge Robert Blazer. He was one of the first American Indian judges here in Minnesota. He had a criminal block and a civil block, and he was the chief judge of the civil division. So we got a variety of major crime cases that we oversaw, and then also some civil trials, summary judgments, mergers, force outs, large development foreclosures. So it was really interesting to see how those progressed through court during that time. Again, I'm a member of the Lac Courte Orielles Band, which is out in Hayward, Wisconsin. I am a graduate of the University of Minnesota Twin Cities campus, and I have a degree in sociology and American Indian Studies. And after that, went on to law school at William Mitchell College of Law, where I was able to kind of pick classes here and there from the other different law schools and focus in Indian law. So I kind of made my own hybrid Indian law program. But I really enjoy the real estate and the land transactions. I think it's exciting to see what tribes can do for their communities, how they can collaborate, set goals, and achieve those goals. And ideally, it's going to be in a way that's going to develop and leave a better community for their youth and for all the members of the community and the greater community too, and neighboring towns. And last year I had the very good fortune to have my tribe LCO contact me and ask me to help them with a purchase that they were considering. There is a nearby golf course just across the street from the tribe's casino, and the owners of the golf course were interested in selling that property. So the tribe's legal department and real estate department reached out to me and asked if I could help them with this project. And we have someone from the tribe's real estate department here today, Nita Kemp, who did a lot of work on this project with us and has a lot of the tribe's real estate knowledge. So she's probably going to jump in and correct me if I make any mistakes, or but she might have some answers too. How many people here are golfers? Show of hands. Okay, we got a couple. How many people here have worked on commercial transaction projects for tribes? Okay, a couple of those. All right, so we're going to get into both of those topics a little bit. This golf course project was a very interesting deal. We thought it would be a very simple project when it started out, that the sellers had a golf course, they wanted to give it to the tribe would give them some money, and it would be all done, easy project. Maybe we can wrap this up in a month. But as we started looking into it and getting more information, we started finding all sorts of little sand traps along the way. And we did our best to assess those and explain them to the tribal council and determine, do we move forward with this or do we walk? And I think there was many times that the tribe considered walking away from this project because of some of these issues. But we were able to be collaborative and creative and come up with ways that still made this deal, I guess, worth it for the tribe, because they did ultimately close. So the concept came up probably, I think, last April is when they first started discussing this between the tribe and the former owners. And originally we looked at trying to close this deal, I believe it was the end of June last year. So that date got pushed. The call for presentations for this conference came out, and we submit, Kekek, the tribe's legal attorney, and I submit a proposal to present on this, what we thought was going to be a closed project. So our dates then got pushed to close into December. Then there was a federal shutdown, and dates got pushed again. So this project just closed on the 15th of March. So just, what was that, a week and a half ago? So we had this presentation. We thought that we were going to present on this deal that would have been done and wrapped up and back in tribal ownership. And, well, with real estate projects and with tribal projects, sometimes things change. And so here we are, a week post-closing, with still a lot of lessons and still a lot to learn. So feel free to ask questions at any point throughout the presentation, whether they are real estate related or golf related. I'm going to try and maybe throw in some golf tips, although, correct me, I'm not the best golfer, so if I mess up on a rule, you can point that out, I won't be offended. So today we're going to kind of go over the purchase agreement, some of the issues we found during due diligence, creation of a Section 17 and why we decided to go that route, the closing that seemed to never come, and then some of the unexpected challenges. I don't know if we've got enough time to get into all of them, but it was an interesting project. So the history of this area is this land is outside of the tribe's original federally recognized reservation boundaries. It's very near, just adjacent, and as we just heard, last year we presented on the tribe's reservation proclamation. So last year the tribe obtained a proclamation which extended its reservation boundaries to the north a little bit more, and then that put this golf course right next to the new reservation boundaries. Jumping back several decades, this property was originally owned by just a husband and wife in the area. They had several acres, maybe almost the whole section. There's quite a large tract of land that this husband and wife owned, the Shepticks. They started parceling it off and selling different land sections to different people for different uses. Eventually, the tribe got some of the parcels of land for a gas station. There's an electric company on one of the parcels. Miss Sheptick still owns some property. Others have been sold off for residential development. There's a subway over there. But around in the 90s is when this idea of let's put a golf course in right by Hayward. There's a huge chain of lakes. It's a very recreational area, good tourism. They thought this is ideal land for a golf course. So Rosalie Sheptick did a deed to a company, Euro America International, and the concept was to build this 18-hole golf course. So that was in 94. That project didn't really pick up right away, but you had that restriction and encumbrance on the land. So it was reserved to be a golf course. Jump forward a few years, 2001, we finally have a group of gentlemen that are interested in developing this course. It's a group of investors, guys that were buddies from high school in the Twin Cities area. I think they had some cabins kind of near Hayward. And so they saw this opportunity. So our key players here is Mr. Bodenschatz. There's another guy, Mr. Lansing, and Mr. Dat. So these three kind of come together and pool their resources and see this opportunity, and they're going to develop this golf course. So they start creating these entities. Hayward Golf Course Development was one of them. And they were able to get a deed. Eventually it went from Sheptick to Euro America to someone else, and then Bodenschatz, who then he worked with the other guys. And again, on their deeds, there was requirements to create the 18-hole golf course, and now their concept included a golfing community that would be adjacent to the course. They wanted to do condos, and they wanted to do single-family lots, and they had this, great vision. I think I saw one plan. There was going to be a pool around there. They probably wanted some tennis courts somewhere, but so they had this beautiful vision of what this land was going to be, and they put that in the deeds. The gentlemen, for each of their interests and investments that they put in, they each got some different mortgages on some of the residential lots and portions of the subdivision. The primary golf course development had a mortgage with the bank. So then they start working with architects and get the first plan in place. And they bring on Pete Dye, who is becoming a famous golf course designer, former golf pro. He comes in with a concept to design the golf course. And for those of you golfers, the first 9 is a links course. So there's not much trees, kind of open, lots of bunkers. The back 9 is in the woods a little more, still some big hills. But Pete Dye is known for putting together some really beautiful, well-landscaped golf courses. So they get him on board, and he agrees to design it. And they've got their different entities set up, where there's the Hayward Golf Limited Partnership and the Hayward Golf Corporation Development. So they're dividing up the parcels and getting different financing for different parts of this development, whether it be the specific golf course, the condo association, or the single-family homeowner association. The architect comes up with the plat, and they've got a local bank, Johnson Bank, that comes in and does some financing. So as part of this, now they're looking at access, and they're looking at specific land issues. One thing they realize with the golf course is, well, you need a lot of water to keep that nice grass growing. So they're starting to look at some different drainage easements and where are those going to be. So those start getting recorded. But this is what the original concept was. So you see the golf course in the middle. The middle area here is where the clubhouse was. And the parcels to the right on this corner right here, those were all going to be the condo units They were side-by-side condos, and then all the parcels along the U and to the left and in the cul-de-sac on the bottom, those were all going to be the single-family units. And based on, where it sat on the plat, how desirable the property was, you can see they had various pricing. This was one of the old sheets from one of the first rounds of when they were looking at financing and trying to get this off the ground. So one interesting aspect about how they set this up was those condos on the right. If you were to take and draw a straight line from where that street on the right comes down to the water hazard at the bottom right, everything to the right of that is actually owned by the condo association, and they recorded a golf course easement for that property. So that's not actual land owned by the golf corporation. It's owned in common by all the association homeowners, but the golf course has a right of access and a right for golf course purposes, for rights for perpetual development and improvements, rights to maintain the irrigation, rights to do any brushing or landscaping and maintenance. And they also have rights for their guests to go into the yard. So, if you're kind of like me, your ball doesn't always stay on the fairway. Sometimes you're going to have to get a little off to the edge to retrieve your ball. So there are some of those golf course rights there. The rest of the parcels for where the golf course is was considered golf course property and was deeded. And then the individual parcels, homeowners were subdivided through the plat. You can see the red is where the sold lots are. This was the original concept. It's changed a little bit, and we've discovered some issues since then. To the north, where it connects up at the top on the right, is where there's a main county road, and that county road goes off to the east a little bit further, about 2 blocks maybe, and then that's where the casino is. So from the golf course on the right here, that's the 9-hole, where you can kind of see the casino from there. So it's pretty open, visible. That's the links portion. Then you have that road that comes down, connects up to the clubhouse, and eventually the plan was for it to go around and connect up to the cul-de-sac, and it was going to end there. It looks as though they had thought about connecting a road in, but the final plat that they filed didn't include a road to the south. It just connected up to that little cul-de-sac there. So there's a proposed pool down at the bottom, but there was never a road that would have connected to there. The road on the side here that goes to these condos, in the original plat, it ended at that last condo on the right. It didn't go along the south. So we have this map that looks like there's access all the way around, but legal access of what's recorded and what we have rights to, it does not connect. So the associations were created, setting forth, much like you'd think you'd see in associations, covenants, restrictions. There's requirements about what your property has to look like. There's association boards that are going to be set up. There were going to be fees for the homeowners, landscaping and environmental committees that would have to approve developments, fences, any construction. None of us who are working on this project were experts in association law, but we reviewed the documents and we knew enough to see that this could be a problem. This could be a concern. And it sounded like a really great idea to have all those properties built up and, nice, beautiful homes that would have, a ready-made population of golfers. But we're also thinking about what's the tribe going to do with this land? And did they want to try and put this in trust later? What's going to happen with that? Because these association documents did have reference to the golf course and owner had a voting right in all the associations. And there was also obligations in there for the owner of the golf course to maintain their property and to keep up the golf course atmosphere. So again, that wouldn't go into disrepair and drop down properties of these real estate developments. So it was very complicated, and we're trying to understand, okay, what does this mean for the tribe? What type of rights do these associations have over the tribe when they become the owner of this golf course? It got a little scary trying to sort that out. So that was one association, the condo association on the right. Then there was the second association, was the single-family homeowners association to the colored lots on the left. So similar, there are two separate associations, but they had similar rights and obligations between the homeowners and the golf course. So now we're actually dealing with two separate associations. And there was also terms in these documents that when the associations were and the lots were sold up to a certain percentage, then the homeowners would take control of the association and start managing the and enforcing the covenants. But until then, it was the developer. So we're coming back to our main key list of characters. Bodenschatz, Lansing, and Dat were our developers. And right now they are in control because, as you can see, they still have some lots to sell. So things weren't quite going as well as they wanted. The lots aren't selling. It's just not taking off. So they start going through the first foreclosure. So Johnson Bank foreclosed, and around that same time, Lansing and Bodenschatz, who had mortgages on some of the single-family lots and some of the outlots, they foreclosed on their interest as well. So this big development is getting kind of parceled up between who owns what. Johnson Bank takes ownership of the golf course, and you kind of have to go through and look as to whether Lansing owns which lots, whether Bodenschatz owns which lots, and then you've got all these individual people who bought these lots that they were going to develop either their permanent home or their vacation home on. Suddenly, the association's going through foreclosure, and what's going to happen? So the foreclosure sale was confirmed. Johnson Bank took title. And there was questions then about, well, what happened to the associations? Do those still exist? What are their rights? And so we had to look and see, were the banks and the mortgages subordinate to the association documents? Did the banks consent to those association documents so that through a foreclosure, those became prior in right and they survived the foreclosure? And again, because this wasn't the simplest project, it was different for the different associations and the different lots. What we found was the banks had not subordinated their interest to the associations for the golf course parcel, but generally for the residential lots, they had. So those associations still survive for the association community and the residents that would be purchasing those. So Bodenschatz and Lansing at this point are kind of weary of going forward on this deal, but this guy, Jack Dat, he says he still sees some vision and wants to keep this project alive. So he comes in and he buys the property from the bank, gives the bank a mortgage. Then he starts looking and starts purchasing different parcels and outlots from the original property, and he's also looking at well, how can he make this deal a little better? How can he help himself and his business out? So he ends up creating another plat. And at the time, Lansing, who still lives in Minnesota, I think he's less involved with what's going on. He's probably moving on to his next business venture. Bodenschatz lives in Hayward in that community, and he's a real estate guy up there. So he's still involved, and he's still trying to sell and market these properties that he has and recoup some of his losses. So now you've got Bodenschatz and Dat kind of going back and forth for negotiating for different rights. Bodenschatz owns some lots, and he sees that Dat's own some, and they've got access issues, and so they're trading back and forth. You know, I'll give you an easement if you give me a right-of-way here. And they're not working with attorneys to do this. They're just drafting documents themselves and filing them. Some of them are, actually, there's, I think, one or two of them that are handwritten documents. Computers were very accessible in 2005. So there's a lot going on as they're trying to figure out how to keep this development going. So we've got more mortgages. Eventually, Dat does get his plat of Big Fish Estates filed. He brings it to the town of Hayward and goes through the whole approval process. So they look at the plat to see what is his plans, what's he going to be doing with this property. And it also goes to the Sawyer County Board. It gets approved and filed. Then with this plat, what Bodenschatz is doing, or I'm sorry, what Dat is doing, is he's taking some space on the golf course and he's subdividing out new parcels to make another association. So his plan is he'll sell those residential lots, make a little more money, can invest it, keep this business afloat. Maybe that was a good idea. I don't know. He gets some more mortgages. So then with his new plat and his new association, he creates Big Fish Estates and files those covenants. So now we have a third association. So here I have the maps. On the left is what it was originally looked like. And then on the right is the plat for Big Fish Estates, what Dat presented and approved. And he got approved by the county. So you can see, you look over here, there's no residential lots along the bottom. So what Dat did, he created 2 lots here, 2 lots here. He put a lot here, which is going to block views from those people. Those lots were owned by Bodenschatz, so Dat now is blocking their visual views of the golf course. He did the same thing over here and created some lots there, snuck one up there, and snuck another one up there. So for Bodenschatz, now this really kills his the value of his properties. And so now these guys are fighting even more. The original plat that the map on the left was created after, when they platted that, they created the roads and they gave access to the single-family homeowners in that plat. So Dat, he just carved out some extra lots out of the golf course. And he assumed that they would be able to access those lots through those main roads. And then he also created that bottom road on the bottom here. So this was a new outlot that he sought to create. And he thought it would connect up to this original road right there. And that was his plan. But again, we've got the 2 separate associations. Now Dat's putting in a third. Bodenschatz is not happy about this. He's losing his views. This property is getting cut up. And so he's starting to look at what's happening. And he says, well, hey, wait a second. You don't have access to your lots. These roads were put in for my single-family homeowners. So they end up going to court to fight this out over access. Apparently this issue it was brought up during title commitments and title policies. And so DAT tried to argue and ultimately ended up going to court on a case for his title commitment policy for his subdivision. But what the judge found was that that original road was only created for the use of that first single-family homeowners association. The road on the right by the condos, yes, it has a golf course easement, but residential lots added after the fact on a golf course are not part of a golf course easement. You don't need a residential house to go golfing. So the access he had on the road to the right was only for golfing. It wasn't for those residential houses. So now we have Dad, who's created all these lots, and there's no legal access to any of them. So that's a problem. He somehow does sell a few of them. I'm not sure what these people were looking at, what type of title work they did, but so there are some people now that own some of these lots that they don't have legal access to. And it turns out the road, Wood Creek Lane, that goes around is actually owned by Lansing, Thomas Lansing. Although all the homeowners have essentially a right-of-way in the covenants to be able to use that road. And then the judge finds that this road on the bottom, there's no way to access it because he tried to create it, but DAT doesn't have legal access on any of the roads to get to his new road. So some of this came up as we were going through our title exceptions. We were looking through, as part of our purchase agreement, knowing that this was a golf course and there was going to be some things we didn't know about. We tried to draft some pretty broad title exceptions. We went with the title company that is local in the area that the tribe knows. This title company also knows that a little bit about tribal real estate and knows a little bit about the BIA and fee to trust. So that was really helpful when we would say, well, we've got questions about this and we're going to have problems with the BIA if we try and keep this on title. They understood and they were willing to and able to work with us. It was Nightberry Title. They have some offices in Minnesota and Wisconsin. Maybe somewhere else too, I'm not sure. But so within our purchase agreement, we had a pretty good section about requiring a preliminary title report, allowing the buyer to review that report and give notice of any disapproved title exceptions. We had some time frames set in place as to when this needed to be done. Then the seller had the opportunity to review those and could respond and either say, yes, they're going to clear title, or no, they're not going to do anything about title. And then it would come back to the buyer to say, well, we can walk away, we're done, this is an unacceptable, unpermitted title issue, or yes, we can move forward, we'll take the property with this exception. So we had this option to terminate in there. And we also had language in there that required the sellers to disclose if there's going to be any new title issues that came up. So kind of an ongoing title check until closing, which was really beneficial, would be really beneficial for us when we ended up going almost a year until we got to closing. So we get the title report back and we're looking through, and there is just a number of encroachments and easements that are listed on the title report. Some of the things we find is some of the deeds that were included on the title report go back to 1904, 1905. So this title company would go back to the original patent and identify any title issues. Some states like Minnesota have a kind of a 40-year statute where if something is older than 40 years old, the title company can take it off, and it's been cured because if someone hasn't given notice or brought up a claim within 40 years, that doesn't, it's not going to be a cloud on title. As kind of a practice tip, if you're going to be going in federal Indian land issues and working with the BIA, if there's a federal claim, that federal claim is going to survive a state statute that says a title exception doesn't apply. So I appreciate that they went back further, but what they were putting on the title commitment was these deeds from 1904, 1905 that referenced flowage rights. And they were kind of standard template deeds from back then when there was a lot of logging going on in this area. And so every deed reserved flowage rights so that they could send their logs down the river. But fortunately, we had a title company that was familiar with the area. And we called them up and we said, hey, there's no lakes or streams anywhere on this golf course. There's a little pond, a water hazard, but there's no flowage going on here. Can you take this off? So they were receptive, they kind of chuckled about that too. And they said, oh yeah. So they took a couple of those off. Another thing that was on there was a use agreement. So back in the 90s when they started looking at this concept, someone had some sort of an easement property right that they were giving up. And so they gave that up in exchange for right for them and their guests to have access to this golf course. Well, that person passed away like 10 years ago. So, we reached out to the title company and we said, can we update this and take this off? We don't, need, this isn't something that is going to be assignable or that's going to pass through probate. So they took that off. There was also a fence agreement. The original owner, Ms. Sheptick, had an agreement with another neighboring property that she wanted to apparently put up a fence and said she would maintain the fence and it would stay there and it would look great and everything. Well, so Ms. Sheptick's still there, but the other person no longer lives there anymore. Don't even know if they're even alive still. But we have this fence agreement encroachment, or not encroachment, this fence agreement encumbrance on our property. And there's no fence. So another thing we had to call the title company about and said, hey, luckily they know, take a look. You don't see any fences out there. So they took that off. But we also found that there was a lot of brushing agreements for some of those residential lots to be able to clear some of the land into the golf course a little bit so that they could improve their sight lines. At some point, they figured out some of these access issues, and so some people were creating rights of way through separate parcels. So some of those were showing up. And then just the general stuff too, utilities, electric, things like that. And then, like I mentioned in the beginning, there was some drainage easements, which is kind of a big issue for the golf course. There was a spot where water was pooling on the golf course, but they needed to put in some pipes and a system and so that the water would flow away from the golf course and keep the greens, I guess, at the appropriate type of moisture and water level. So they had to obtain an easement so that they could have all this water diverted and drain off into one of Ms. Sheptick's properties. And in consideration for that, she's another person who then got access for her and her guests to come onto the golf course and golf and enjoy the facilities and amenities. But that one stayed on the title. And so it was in the title report also that came up the litigation about access to the road, which then really got us thinking, okay, what other litigation's out there? So we found ultimately that there was the 4 different foreclosures that this property had gone through. There was a litigation about the access road, and within the litigation on the access road, there is an indication that all these foreclosures hadn't been very clear about the association rights on the golf course property and on the association properties. So we realized then, okay, this is an unsolved issue that could come up. And these lots there's only a few of them that are developed. Maybe 5 of them are developed. So there's like another, 70, 80 lots that people are going to try and sell, eventually develop, and probably try and step into this association and regulate. So that was a big kind of cautionary flag for us. And we presented this to the tribe and, asked, do they want us to dig into this and figure out association law? Do they have questions or concerns? And we were trying to figure out what to do about that. Ultimately, they did want to keep moving forward. So other things we looked for in our purchase agreement, we put in the right to look at environmental and structural concerns. So with the golf course, one of the big issues is the grass. You're going to need to be able to maintain the grass. There's a lot of cutting, a lot of pesticides and seed that's going to be involved. So they had some specific licensing and approvals from Wisconsin to be able to use certain pesticides and for some of this to flow through. So we asked them also, when we had rights to look into water contamination. Are we going to be having problems with this, just the natural flow of all these chemicals into the water and spreading out into the community? Because now we realize we've got these residential lots nearby. So that was one thing to look at. We reserved the right to do soils testing phase 1 to go in and actually physically inspect the property. And very important for our deal, because our seller, the corporate entity, was in Arizona. So when we call them and ask them questions, they're up there maybe once a year. They have no idea what's going on with the property. They had somebody else managing the property, and the individual that they had managing the property was a gentleman who'd retired and thought it would be great to, hang out at a golf course and manage it in his retirement. Fun, nice little hobby. But he wasn't a detail guy, and he doesn't have paperwork or documents or contracts. So he didn't have a lot of good details and wasn't able to answer the type of questions we want for real estate transactions and contracts. And but the tribe did send some people from their environmental department to go out and inspect the land. We discovered, there's some tanks out there. There's an above-ground fuel storage tank. There was a below-ground fuel storage tank, and we got those were related to the business. They use those tanks to keep gas for the golf carts. But we addressed that with them and asked that those be removed. And then when the tribe's staff was out there, they realized, oh, hey, back in the woods, you're kind of using that as a dumping ground for, is that broken golf carts and other equipment, machinery. So again, had we asked the seller about that, they wouldn't have known, because they're out in Arizona, and getting out into the property and physically looking at it helped us discover that. Also, looking at the structures, we reserved the right to have a building inspector come out, and the tribe, again, sent some of their employees out to kind of walk through all the buildings and take a look at them and see if there's any issues or concerns. And then also to look at other property and equipment that was on site. We requested permission to communicate with local authorities who would have been issued any license or permits, or, so we talked with the county zoning to see, is there anything coming up that might really impact us and any development we want to do if we want to try and build up some of these lots? So we just made sure we had full rights in our purchase agreement to do all the diligence that we wanted to for environmental and structural. So again, then once we get out there and we're looking at our surveys, we're looking at our deeds, we're out on the ground checking things out, discovering more issues, because it's the project of never-ending issues. We realized that where Dak created all these new plats for his new subdivision, and he carved up the golf course, the golf course cart paths were going right through those lots. So we've got encroachment issues, and some of those lots he had sold to other people. Some of them ended up going to Silverleaf, who was the seller. So, you know, they're kind of encroaching on their own property, but it's an issue if you ever want to sell those parcels. So, you know, here's kind of just a messy map of one thing I was working on as I was trying to understand this. I was putting together maps, drawing, highlighting colors to understand who owned what rights were where. So you'll see in red are the parcels, or some of the parcels that the tribe was going to get with this deal. With the project, they were getting the golf course, and I want to say it was like 12 residential parcels. So in red are some of those, and you can see where the green lines are. So that's where the cart path was going, like clearly through these residential lots. The ones in yellow on the left, those were a few that had golf course easements in place for an identified number of feet within the plot. And so on those ones, we were okay. We have the right to be encroaching with our golf cart path there. But on the orange and the red ones, there's nothing in place there. So that was one issue we identified as something we're gonna have to clean up and make sure that we have, that before we sell those, we have rights to have our golf cart path going through there. The lots in the purple have brushing agreements. So those people have rights to go past their property line into the golf course line, and they can remove brush that's 4 inches in diameter or less. So if they want to improve their sight line into the golf course, they have the authority to go clean up the golf course property and remove some of that forest and brush debris. So again, another interesting thing that came up was in that very first plat that created the 2 subdivisions, the small condo association on the right and the first single family association on the left, that went through, was surveyed and filed with the county and approved. Then about 10 years later, we're looking at a different survey, and we see in this blue area up there identified a wetland. So there's a wetland that covers 2 of those residential lots, goes over the street and into the neighboring adjoining parcel. So that road has never actually been developed. That creates somewhat of an access issue to get to all those other all those other houses that are on the left. And what they ended up doing, Mr. Bodenschatz, again, who's the guy who lives in the area and owns a lot of these residential lots, he purchases a lot far up north to the left, and then he buys an easement right through another northern property and grants easements to the parcels that he owns. So he creates access for his benefit, but not everyone else. So that ends up being right up here, that parcel right there, he bought, and it's one of the golf course plats. And then you see the street going up forward. He purchased a right-of-way driveway easement and gave access to, like just whatever few parcels he owns right in there. So, so still problems with not full access to everyone. And you'll see there is one house, that little dot on the left there. There's an actual house there. It's the only development on that side. On the right side off True North Lane, there's a few other houses, and then there's a couple over in this condo association. So there has been some development, but again, there's so many access issues, and now we have to be careful about the access and the encroachment, and be strategic on how we resolve some of these. I mentioned earlier, DAT put in some of those properties blocking off Bowden shots and their views to the golf course, so that's going to be another issue that'll have to come up, and whether or not all these lots can be developed on. Another thing we discovered when we went out and actually got on the property, so there's that road across the bottom, which actually isn't a road. None of this is developed. It's all kind of dirt path where it looks like maybe four-wheelers, maybe trucks have gone through. At one point, DAT was trying to make the golf course more appealable for tournaments. And so he added, I want to say it's black tees, which are even further back. Am I getting that right, someone? Thank you. So he added black tees so it can make it more of, I guess, a further yardage course. So in this area over here, all the other tees were in this spot, but in order to get the additional yardage, he has a tee off from the black hole right here. So when that road goes, we're going to have to do something, either buy additional land to go around it, or get rid of that black tee, because right now it's in the middle of where a road would be. So that was kind of interesting to see, to drive the property and say, wait a second, I'm on what's going to be a road, and there's golf over here and golf right there, and that's not going to work out. So again, just so many interesting issues that came up with this property. So again, with it being a golf course project, we looked at, memberships and gratuities. We want the membership base that's already included with the golf course. There was memberships that had been sold, and memberships that came back, each year they sell them on an annual basis. We looked at this project started last summer, and at that point, they had a list of different membership categories. So we made sure in our purchase agreement that all of those memberships were going to be assigned. Not only for the memberships, but also for the client base. We've got a marketing database right there of names and addresses and emails of people to market to and invite out and offers. So that was a very valuable asset that we wanted to include. So we drafted, for all those extra things that weren't physical land, we drafted assignment agreements. So we had an assignment of memberships and gratuities. With the gratuities, there were gift cards that had been given out and where people hadn't redeemed yet. So they had a software system that tracked all of that. But again, I mentioned that there's this gentleman who was kind of doing this as retirement and didn't like to keep track of contracts. So a lot of the employees and a lot of people who came to work, he just said, oh, hey, thanks for coming. We'll give you a couple free rounds of golf, or you'll have a free membership. So they tracked the memberships and the passes, but we didn't necessarily write down the agreement of what the work was, when the work was to be done. So it was just really messy. We saw a trend of certain individuals getting quite a few gift certificates and had memberships, and it was something to definitely think about. But in the purchase agreement, those got transferred. So we were supposed to honor those memberships, those gratuities. And so they had a schedule of everything since they had it in their computer software. But we also allowed for those adjustments to be made during prorations. So they received a charge because they'd already been paid for those gift cards or received service. So the seller received a charge, and we received a credit because the buyer would have to honor that. So it was getting offset on our closing statement through our schedules and prorations. But again, something that came up and we had to look into it, and we explained it to the tribal council of how this was going to be included and transferred in the project. Permits and license were another key thing to have assigned in the purchase agreement. We wanted the ability to sell alcohol on the course. There's also a clubhouse and the main clubhouse, and then there was kind of a smaller clubhouse where both had the ability to sell some food, burgers, drinks, but we wanted to make sure then that whatever food service license they had would be transferred if possible. And then there's that pesticide. You have to be licensed. You have to go through a course and take a test and be licensed to actually apply the chemicals. So looking at all that, the software license to use it's TSNAP, it's a software program that collects all this information, your membership information. It also connects to your website, so people can buy things online, register for tea times online. We needed that database and that access too, so it would be a seamless transition. Especially looking at doing this in the middle of the summer, what was our original thought is we didn't want suddenly for it to switch over on Friday, and then what happens with everyone's tea times on Saturday or their memberships. We needed a way to track and transfer so we can continue to honor those. So in our purchase agreement, we required all that information to be disclosed and all of it to be transferred. We reviewed that to find any other issues, and we did discover that some of the permits and license may not be transferable. So the pesticide application license, that's individual to a person. So we still have the same guy. He's coming back and working this week on the golf course right now. And then the liquor license was expiring, so they were going to be reapplying for that.
Will that be a not transferable, the pesticide license? Someone's gonna have to go take the course for whatever reason.
Yep, they're, yeah, and so that's actually come up because now here we are now, it's spring, and the snow's melting, and so the corporation managing the golf course needs to start preparing the greens, and they've had to look at, okay, well, who's capable of assessing whether there's snow mold or whether there's other fungus growing on the greens, and which chemical to apply where and how much. So we ended up having to bring back the same guy for now to try and figure this out. At the time in the summer, we were looking at transferring a full operating golf course, and we needed staff that knew what they were doing. So, and we needed the services in place. So in our minds, we were thinking, okay, transfer all the contracts, transfer all your vendor agreements, whether you've got your agreement with like Coca-Cola or Pepsi or, whatever liquor distributor is in place to stock whatever contract you have for maintenance. If someone's coming in and cleaning the property, we wanted all those contracts to come with. So we included that in the purchase agreement. And when it came to time for the due diligence and we asked for them, they don't have written agreements. So we pushed a few times and we asked and tried to identify specific things based on what we found, and they came up with a storage lease agreement, which we said we don't want your storage property off-site somewhere. You can keep that. They were looking at a Toro agreement to maintain the sprinkler system, which is another big, huge asset with a golf course. But they never finalized that agreement, so we never were able to get the Toro maintenance system for the sprinkler system. And then we discovered that they didn't actually own the golf carts, that those were on lease. So that was the one written agreement that they were able to produce that we said, well, yes, we want that one. And then we, had to take a look at that, and was it assignable or not? And, but we had assignment and assumption agreements included so that any contracts and agreements they did have would come with. We originally looked at having the employees, whether they would come on board or whether they'd be terminated, and we'd start with a new force. Last summer, I think they had like 20-some employees, and when they heard, once they started finding out like this is going to go forward, they took it upon themselves to hire more tribal members to train them in who would come through the workforce. Well, then they went over their budget, their employee wages and salaries budget, and tried to bring that up to us as, a need to negotiate for a different price. And we said, well, wait a second. We didn't tell you to hire more people. You were just supposed to operate business as usual, business as needed. Like, sorry that you overstaffed. But, hindsight now, here we are in March, and we just closed, and it's seasonal business. So when we actually transferred it, there was only 3 employees that are employed. It was the manager and 2 accountants and finance people. So those are the people that are coming with as current employees. So some of the contracts that, again, we also tried to look for was tournament banquets and special events. Throughout the summer, the golf course would host different golf tournaments. It's in this area that's a lot of traveling native fundraising golf tournaments. So those were on the calendar. There was a couple weddings. There were some reunions that were on there. And when we were looking at this transferring in the summer, we said, okay, if we're going to take this over and there's a wedding in 2 weeks, we need to know who those people are, what's expected, what areas they're going to be using, what services are we to be providing. And they didn't have those details written down for us. So, last summer it was very concerning. And they said, identify this person, speak with them. Now in March, they have a whole list of things on their calendar. Again, they still don't have any contracts in place, but at least we've got some time to plan, and there are events that we can follow up with now. So that's something that's been transferred to the new management company to look at getting contracts in place and getting those details. So we know, do we need to order food? Do we need to have separate security or separate insurance and liquor license? Like, what's going to happen at this wedding, at this reunion, these golf tournaments? What are we expected to be providing? So I mentioned a little bit about the irrigation system. And again, that's a very important piece of your golf course. It's, it keeps it looking nice. And so we did address the irrigation system specifically. We asked that we get information about when it was installed, whether there's any inspections, whether there's been any damage and any repairs. And as customary with this project, they didn't really have a lot of information. But they did say they did on site have some files. And so we were able to send someone down who looked at their irrigation system, and in a file they did have manuals and reports of how it had gone. And I believe there was some damage that had been done to the irrigation system a few years back that had been repaired. But an irrigation system itself is about $1 million. So that was a very big financial piece of this that we wanted to make sure was in good order, and if there was any work done, that there was warranties that we could rely on, that would be transferred to us. So we made sure to address this in the purchase agreement. And again, we looked at some of that pesticide, water, drainage use issues, whether there be anything that came up with those. So just here's another picture of the golf course, and this one is it's upside down. It's actually the top of the picture is to the south, and hole number 3 at the bottom is actually to the north. So all of your condo units are going to be on the left side, and all your single family are going to be on the right side. But you can see along hole number 7 there where that that water hazard is, there's, right underneath that, there's a bathroom sign, and that's where the irrigation well house is, that we were able to get in and look at kind of the data that was collected there. And at the top of 7 is where one of the pumps were just to keep the irrigation system going. So the community and land use issues, we have these multiple residential communities that were planned, and we had to take a look at those and think about what's going to happen with that. So again, we looked back at our title commitment to see what rights and what requirements were in place. That's where we found a lot of those brushing easements. But one thing to think about with a golf course purchase or even any other purchase is what activity are you doing and how is it going to be impacting the neighboring parcels? For us, it was pesticide spray, golf balls going into other people's property. Did we have easements for that to happen and to impact other people's property? I'm sure you see it probably in farming, similar pesticide issues, where is the pesticide overspray going into your neighbor's property, and do you have a right to do that so that you prevent trespass? And there might be similar issues with noise, if you've got a dirt track, BMX track or something that you do as a business in your tribe. Is there a lot of dirt that's getting sprayed up and debris going to people's yards? Is there a lot of noise and you have a right to kind of encroach in their property with that noise and that dirt? So, we've looked at what's the neighboring community look like? How are we impacting that? Do we have the rights to, or are we going to run into any issues there? So here's a little golf tip. A ball is out of bounds when it crosses the white line. If it's on the boundary line, it's still in play. So again, we needed to look, and this happens all the time. Where is your boundary on your property? And do you have the rights to go into those other parcels? And again, some of those new properties that I showed you, not only do we have a cart path going through those new plats, but then you're also going to have people accidentally hitting golf balls in there and stepping into those yards to retrieve their golf balls. Do we want our customers to be subject and at risk of getting a trespass claim whenever they want to go get their golf ball? There is some inherent liability and risk if you build your house on a golf course, but that doesn't necessarily mean that the golfer, has the rights to go onto your property. And so as the owner of a golf course, when you're inviting people to come and enjoy their recreational space, you want to make sure that they're protected to some extent within your control, and so that they don't have to worry. So intellectual property was a big piece of this project too. Again, I mentioned this golf course had the name Pete Dye. He was a golf course designer. People in the golf community know him. He's done courses across the country, across the world actually. And so that we saw as a very marketable piece that we wanted to keep. We wanted to be able to advertise this as a Pete Dye golf course, and people still know it. It's a Big Fish golf course designed by Pete Dye. So we asked, what type of license do you have to use Pete Dye's name? What type of agreement do you have in place? And shock, they had nothing. We asked what type of trademarks, intellectual property rights have you registered for the Big Fish golf course, Mulligan's Pub, and we asked that those be transferred too so that we could protect those. Big surprise, nothing. But we included it anyways. We did a search to see had anything been recorded. were there any trademarks? Because again, we've got a seller, there's been many different entities that this has traveled through. Has anyone ever recorded something? Or does anyone else have something recorded that we could then be infringing on? So we wanted to make sure that that was addressed, and we had so it was in the purchase agreement that's included with the sale, and then we also have a separate assignment of intellectual property rights that we sign at closing, in the event that there are any property rights, because there is some argument that they have been using it for a while and have the established name, but so again, due diligence for environmental aspect. Water rights was a key issue, so we looked at that. Looking for those wetlands and how they're impacting the development. Because now we've got this access issue and this road, well, we still are gonna have to figure that out, but we at least need to be aware of it. And then those drainage issues, where's the water going? Do we need any more drainage easements? And I mentioned there was the gas storage, the oil tank storage, or gas tank storage. So we need to make sure that we had appropriate certification for those. They did produce those. We do have proper documentation that they can do that. So for the title commitment, again, we looked at future fee to trust issues. What's going to happen? If the tribe, we advise the tribe that if they want to transfer this into trust, it's going to be a long time, and there's going to be some big issues that will come up if we try and do this. A lot of cleanup that would have to be done. And so that they were fully aware and understood that we're not buying this as a fee to trust, reservation proclamation, that we're going to suddenly add this to the tribe's reservation. It's going to be a long time before that can happen. We can work on it, we can look into it, but it's not a quick fix. And then we looked at the golf course easement language, because again, like I mentioned, there's rights to get into that condo association for golfing purposes, but that doesn't include access to a residential lot that you add after the fact. And then the neighboring community does have some rights to use some of the land. So, we just looked through all that as part of our due diligence phase, which again then led to those court filings to figure out what disputes had been resolved, which ones were still open. Were there any liens or foreclosure issues that were still present? And there was a mortgage that was still on the property, and that was going to be satisfied. That was a mortgage that was dealt with the seller and one of their other entity companies. So just another map again showing like how all these real estate issues were coming up and things we have to plan for and kind of work around, because we've got those cart paths in green that are encroaching on properties. We have golf easement to use, so it's all of this right here is where the golf course goes, and there's that water hazard there, and that's where the pump house is. But this property is all owned by this homeowners association, and we just have a very extensive perpetual easement for golfing purposes to use this, which includes that road that ends there. So kind of understanding those property rights and explaining that to the tribal council, those brush agreements, and all the other easements and access issues. So another aspect of the project is this golf course. We want to know, how profitable is this? How are they doing as operating it as a business? Are they making a big profit? Are they just breaking even? Are they losing? And maybe this isn't a surprise, but they weren't making the hugest profit. They had many years of loss. That might be reflective of the fact that they didn't record anything and document all their agreements. They also we found some employee theft issues in the back, and there had been some claims and some criminal cases as a result of that. But we asked for their records, and so they sent us monthly balance statements, profits and loss statements, annual budgets, annual projected budgets and actual budgets. We did title searches on personal property to see had anyone filed, had there been any lenders or other entities that had filed any liens on, maybe the golf court or the golf carts or any of the other equipment, some of the cooking equipment. They also had an indoor golf simulator. Was there any liens on that? So we checked the entities to see, have there been any other UCC liens where someone might come in and take some of the equipment? And then we required the sellers to provide documents about their entities. We wanted to see that they were properly formed, that they were in good standing, and that they had proper authorization to do this transaction, and who had authority to sell. Yes. So, lots of problems that came up and lots of reasons to run for this project. But it's a golf course right next to a casino, and there were some ways that this could be a good amenity to the casino and to the tribe, and so they wanted to go forward. So we thought, how can we do this? And we looked at a Section 17 corporation. So under the Indian Reorganization Act, a tribe can create a federal corporation that is approved by the Department of Interior. It then becomes, a separate federal corporation. It's separate and distinct from the tribe, but it shares in the tribe's, it can share in the tribe's sovereign immunity, and it can share in the tribe's tax status and be tax exempt. So, but one of the key issues for us was that a Section 17 corporation can sell land without needing separate approval. And, the Non-Intercourse Act and Federal Indian Law, a tribe, unless they get a separate authorization from Congress, is not easily able to sell land. They would have to go through Bureau of Indian Affairs and get approval to sell land. And this development had specific residential lots that we may want to sell to people for their own development. So we knew we needed the ability to quickly sell a lot. It wouldn't help us if we said, oh, you're interested in buying this? Well, let's just hang out and wait for the BIA to work on this and give us approval. It'll take 3 months to 2 years, So for those reasons, we thought we need to do this in a Section 17 corporation. We really liked how it's separate and distinct from the tribe. Because of all that litigation that's happened, we thought, what's to stop all these people from just filing in court again? They've done it many times. It's likely going to happen in the future. Once the tribe gets on board, are people going to look at the tribe and say, this is a cash cow. We're going to look to them and require them to do this development. And we wanted to protect the tribe from that. We didn't want people to just come out and try and any of those residential lot owners, people who might have concerns about easements, encroachments. So we created the Section 17 corporation so it could be separate, and also a separate board who could manage this as a business and operate it as a business and make business decisions, whereas your tribal government, your tribal council, is providing programs and services and governance and supporting the community. So those goals may not always align, and for that reason, we also felt Section 17 is the way to go. We need separate business board operating this.
Is this, that was the first time I ever heard of it. I mean, do other tribes do this? Is it common or? Section 17? Yeah.
We don't see as many up in this area.
That's the first I've heard of it.
Yeah, there is, I haven't seen many up in this area. What I have discovered is that some Wisconsin tribes, some Minnesota tribes, and Michigan tribes, when they were going through IRA, if they selected to have an IRA constitution back in like 1930s, then at that time they were also just getting a Section 17 corporation. And so there was a kind of a template Section 17 corporation, and some of those those template documents had a sue and be sued clause in them. So a lot of people have been kind of hesitant to use the Section 17 because it includes a waiver to be sued right there, whereas one of the benefits is you can preserve that sovereign immunity. So in some of these tribes, I was working with another tribe and on a deal, and we started going through records, and we found like, oh, hey, you've got a Section 17 corporation from like 1936. Did you know this? And I said, no, we had no idea we had this corporation, and they are only dissolved by act of Congress. So those ones that were created are still sitting out there, even though they're inactive, maybe have no assets and aren't doing any business. Yes, as the corporate charters that a tribe when they get a corporate charter. Yep. And so it's outside of the tribe. It's not under the tribe's authority. If the tribe has its own business code to charter its own entities, it's not done under that process. It's done under the BIA's process. And there's not a lot of regulation or code on how to set this up and how to do this. And when we called the local agency and asked them, we got to give them a heads up. My approach is to work closely with the BIA, treat them well, and they will treat you well, and you'll get things pushed through. So we gave them a heads up, said, hey, we want to do this. We need to push this through quick. How quick can this happen? And they said, oh, wow, the last one we worked on took over a year. And we said, well, can we do this in 2 months? I told them, well, I'll be responsive. I will communicate with the tribe and push them to get what we need and get you what you need so that we can get this all done in time with our closing. And at this point now, we're looking at, it was late last summer, August, when we were doing this, and we notified the sellers, okay, so we're probably not going to be closing this summer. We want to do this Section 17 corporation, and they weren't even aware of all the litigation in the history of this property. They had bought it as a distressed asset in a foreclosure sale. That's just what their company does, is picks up land at cheap prices, holds onto it, and sells it later to make a profit. So we explained it to them, and they were willing to then, kind of push this out and said, okay, we understand why you need to do this Section 17. We'll extend our closing date so you can get this set up. And so we looked for what was out there as templates for Section 17 documents, and there is something on like a Department of Energy, U.S. Department of Energy website, and we thought, hey, let's use this. This is published and it's out there, and we'll model ours after this. And when we handed it into the BIA, they were like, oh, why did you take that one? So you'll see that one out there, and there's a lot of problems with it, but make sure you reach out to the BIA and talk to them first. So we drafted it up and included some key aspects for, purpose to operate a golf course, to be able to do real estate transactions, to be able to do financial transactions. And we submitted to the BIA, and we had the tribal chairman contact the superintendent and say, hey, this is a priority. This needs to happen. And at this point now, we're getting to a point with the seller where they're starting to get concerned about this deal not closing, and they were thinking about asking for penalties and fees for delay. So we let the BIA know, like, we've talked them out of this right now, but this is being proposed, and if we don't get this pushed through and close, we might be hit with fees if we want to close this deal. So the process to get, another reasons why, because it's good for kids to do your Section 17. Those are my kids. And then the tribe's golf course fundraiser that's coming up. But the process for a Section 17 is you get your articles and everything reviewed and approved by the tribe. You submit it to the BIA. They review it with their tribal operations officer. If they have any questions or concerns, they'll send it back, ask for revisions. Tribe has to sign off on those again, another resolution, back up. So then the BIA, when they're done at the local agency level, they send it off to the regional office. So that tribal operations officer looks into it. And we made sure to give everyone a heads up and keep in contact with as many people as we could so we could push this through. So they reviewed it. They sent it out. The regional tribal operations officer sent it out to the legal department for review. They put all their comments together and they sent it back to us. And so it was a pretty comprehensive list of comments, but it was very simple stuff. So we adopted almost all their comments, which really just helped clean it up quite a bit. And there was like one or two things that we said purposely we're not going to address because we had different intents of what it was going to go. And I think it had to do with meetings with the board, the member of the corporation who was the tribe represented by tribal council, and then meetings of the board. We had different time frames, and we did that intentionally because we realized our golf course board is probably able to get together quicker and needs to get together quicker, where our tribal council might have other things on their calendars and would want a little more time for the notice. But so once we did all that, we got this sent back up, and now we're at December. It's been about 3 months. The tribe has approved all of their changes, and we're sending it in, and the BIA says, hey, we need a resolution. And they also say, hey, there's a possible government shutdown in a couple days. Oh, and if not, it's Christmas. So we were pushing. Can we get this done in time? And we had just about everything ready. We had everyone on notice. We had the tribal operations officer. She had everything prepared. She had her memo to the solicitor prepared and his draft. Her memo to the regional director and his certificate of incorporation prepared, so that way he could just sign off on it. And so the government shutdown happened. The BIA is a ghost town, and it's Christmas. And the tribe is looking at this, and on December 27th, I get a phone call, let's do this tomorrow. And I'm thinking, how is that even possible? When we've been close to closing so many times that now we know all we have to do is change dates, but we still have to get BIA approval, and we know they've got everything. So I was able to track down the regional director on the night of the 27th, got a hold of him on his cell phone because he was the only one around, and asked him, hey, if I send this in, can you look at it? And I think at like 7 o'clock that night, he sent me back a certificate of incorporation. So went through, spent that whole day and the next morning revising all of our documents for a deadline of the 28th. But so we got there Friday, December 28th. In the middle of a government shutdown, we had everything we needed from the BIA, but there was concern from the tribe about the optics of being in a government shutdown, programs and services not being funded. Why would you buy a golf course at that time? So we continued it. We took some time, slowed down, got all of the Section 17 corporation pieces in place, got our board fully appointed and up to speed, and we waited for the government shutdown to pass, and we scheduled it for March, and we just closed the project on March 11th. So there's plenty of issues. It was a very interesting project with quite a bit of drama, but now the tribe owns us and they're getting ready to open it and operate it. And if anyone's in the area, they'd love to have you come up to Big Fish Golf Club and hit around. So I think we're done. If there's any questions, I'll be around.
So if anybody has any that's so weird. Any questions right now, I think we've got a couple of minutes still.
So what about deed of trust though? You don't need to do that then, right?
The question is, what about the fee to trust? And so right now, no, we don't have to do a fee to trust. The corporation owns the property in fee simple, and If they want to do feed a trust, we're gonna have to really dig into those association rights and whether anything survived those foreclosures or not. So, do those associations have any rights and covenants that apply on the golf course? We'll have to take a look at those golf course easements. One thing we thought about was if we wanted to amend the associations, we took a look at their articles and we took a look at Wisconsin statutes to see, well, how do you dissolve an association since there are not that many people that are actually living there? And when does it transfer over from the developer to the homeowners? It's possible. You can reach out to everyone to figure out, and get everyone on board to sign off and terminate the easements and terminate the association. But that's a lot of people to track down and a lot of people to get to agree, especially when they're not there. Maybe when the properties are developed and people are living there, it might be easier to say, hey, everyone, like middle of June, come on down to the golf course for an evening for an association meeting. Let's talk about this and let's vote and approve to dissolve this. But it's an issue that'll have to be addressed at a later date.
I'm surprised they don't all them lots.
Yeah. Yeah, they haven't decided yet what they're gonna do with all the lots.
Right. Hello, Bill Tovey from Easements Tribe in Pendleton, Oregon, and I appreciate this. We're in the process of buying their Pendleton Country Club. That's a non-Indian facility. There's not houses there. We've got all the land is owned by the country club, but, you know, a lot of the things he's talking about is important, you know, the membership and the gratuities and their water system is pretty well shot. Their clubhouse is in bad shape, but it's just interesting, you know, 30 years ago, I was a member of that club, and you could just tell, you know, the racism kinda, and now they're coming to the tribe for us to purchase it, so.
Yeah, yeah, that's interesting. We also, what was I say? We reached out to other neighboring tribes that have golf courses to talk to them. What are their recommendations? What are the big issues they see? How do they manage it? And we found a lot of the nearby tribes were very friendly and said, anytime, you know, we're willing to borrow you one of our superintendents to come over and train you in, answer questions, you know, if you need sample job descriptions. So we found that was a good resource, is just build those relationships with our neighboring tribes, talk to them, and they were willing to help. And so they're kind of, right now that they're trying to get everything going, they're, the board is reaching out to some of those people for advice on what to do for the next season. We also did a feasibility study, or not feasibility study, we got an appraisal of the property, which looked at, because there are other golf courses in the area, to see what is this property valued at, and what have the other properties sold for. So that was helpful information.
Okay, before everybody disappears, thank you again, Shauna. It was great presentation, and I appreciate you all attending, and I think we got a break now.
Thank you.